All right, well, good afternoon, everybody, and thank you for bearing with us while we solve these minor technical problems with the assistance of our technical manager, Mr. David Lammy, MP. If I can just introduce myself, I'm Stephen Hoffman, a former chair of the Society of Labour Lawyers and a member of its executive. As you all know, back in August, the government set up what they called an independent review of administrative law. And in order to respond to this review, we decided to set up our own little working group to prepare and put in a response. We were lucky enough to persuade James Goudie, also a former chair of the Society, to chair that working group. And our colleagues Sarah Sackman and Sam Fowles, who you can also see on the call, joined him with others, and they prepared a most impressive 75-page response, which the panel, chaired by Lord Fowles, a Conservative peer, is now, we trust, perusing and absorbing. But we thought that to enable all our members to hear about this, to know about the issues, and to hear from the group which drafted this response, that we would arrange this webinar, which is what we've now done. But we're particularly grateful that David Lammy, our good friend and the Shadow Lord Chancellor and Secretary of State for Justice, has kindly agreed to join us. And in a moment, I'm going to invite David to kick off our discussion. And then I will come to James and to Sarah and to Sam, who will each outline part of, at least, of the submission that we put in, and then we'll open it up for questions. As you know, this is being recorded, so if you want to listen to it all over again, you will have the opportunity to do so, and others who weren't able to be present will also be able to listen to the recording. All I want to say before coming to David is that we do very much want to make this an interactive session. So if you have questions or comments to make, would you please be kind enough to either to write them into the Q&A box. I'm sure you're familiar with that, at the bottom of your screen. So you write them in, and I will then be able to see them and answer and put them to the panel. Or alternatively, if you use the raise hand button, then you should be able to identify yourself, and if possible, we'll bring you in that way. But it would be best, I think, if you put your questions in the Q&A box so that we're sure that we can see them. And please do that as the discussion proceeds. So, David, it's a delight to have you here, as I said, and can I hand over to you to kick us off? Thank you.
Well, look, thank you very much, Stephen, for the invitation. Thank you to the Society of Labour Lawyers for all that you do and for putting in a submission in this area. Lovely to meet you, Sam. I've known James Goudie of old, terribly eminent, so wonderful that you're with us. And Sarah Sackman is a dear friend. So this is a very cosy club in which we can talk about judicial review. I think probably the best thing for me to do is just to be clear on what I think, and therefore the official opposition thinks, is the political envelope here. I want to try and do it in a not hugely partisan way, but I mean, I think it's almost impossible. It might have been the case that, frankly, after the divisions that we've seen in our country following the referendum debate and the decision to exit the European Union and the fractured way in which the UK now finds itself, it might have been a case that there was a serious need, actually, in a cross-party way, to think seriously about our constitutional arrangements. And there will certainly be people who are listening today that might feel that the time has come here in the UK for a written constitution that might govern the way we do things here, particularly in England and Wales, a Bill of Rights. There may well be the case for that, and it's certainly something that a future Labour government would want to be thinking about. I see absolutely no basis at all for reforming in any substantial way judicial review, save for some of the areas that I'll get to in a moment's time. This feels deeply political. It feels as a result of the reckless decision by the government to prorogue Parliament, and that having to go all the way to the Supreme Court. And it feels like a decision to kind of get one's own back, to get the judges sorted, as has been indicated in leaks in the past. And it's deeply worrying. Not only is it flowing from prorogation, it's also coming as a result of the attacks on the rule of law, the attacks on activist lawyers, the attacks on lefty lawyers, leading to a situation in which there was a very, very sad and depressing aggressive move on immigration lawyers here in London. Very, very worrying indeed. And a decision by this government to step back from an international treaty that it signed up to in terms of the withdrawal agreement, and to end in a situation where we might jeopardize the Good Friday Agreement. So that's the context in which I think there are some that believe that any challenge on the executive is a challenge too far. It's small, it's low, and it's not something you would associate with a mature democracy. And I think that's what flows in terms of judicial review and why we are at this point. And so the whole posture of the Labour Party is to be very hostile to this move, because we can't really understand where it's coming from. Look, we looked at the members of the Fowles review. There were some very serious people. We're open to seeing what flows, but we're worried that we hear today that there will not be publication of the responses to the review. And again, why are we running away from proper transparency and accountability? And it's very worrying that this becomes a very political process, as it goes not, by the way, solely to Robert Buckland to consider the responses and the findings, but to Michael Gove as well, whose views are well known in this area. So we are very, very nervous. Our position is rather hostile, frankly, to what is being got up to, and it's for a number of reasons. The first is, of course, this obsession with the executive and executive challenge, when in fact the lion's share of judicial review is towards local authorities, towards health authorities, towards the police and others. Judicial review is not a tool used solely to challenge parts of government. And when it is used, it's used quite judiciously, because we all know it's staggeringly expensive. It's not something that the ordinary individual can use. And therefore, that's a barrier in of itself, because, you know, between 80,000 to 200,000 pounds is not something that many of my constituents have got in their back pocket. In fact, it's not something that the average Brit has got in their pocket. You do it because you're really serious about the matter you're challenging, and you do it often actually with the support of civil society, the support of the third sector, not-for-profits. And I'm thinking, when I say that, about those who gathered round following the decision by the government not to wait for Wendy Williams's review into the Windrush scandal, but to go on and continue deporting people to Jamaica. And I'm thinking of those who were detained, who were not even given access to their own phones, who judicially reviewed that decision, and some who were successful in not being deported. That kind of individual, often in a deprived setting, not some sort of staggeringly prominent or powerful individual in the fabric of our country who's able to rely on the support in that context of the immigration lawyers supporting them, taking that judicial review and my God, the right judicial review to take. Or I'm thinking of the victims of the Hillsborough disaster, challenging not just once, but several times the decision making that, of course, ultimately led to some justice for them, even though it was 20, 30 years in the making. So judicial review is used by ordinary people. It's not just used on the executive, it's used on many, many other parts of public life. And I think it's a very important tool. We also know that actually this year, partly because of cost, I suspect, actually there's been a fall in those exercising judicial review. So again, it's peculiar to mount this challenge at a time when actually the amount of judicial review taking place is dropping, not increasing. And I suspect also in the context of the recession that we're now in and the post-pandemic economy, it's hard to see actually how there's going to be any significant rise over the next period because of those financial barriers that properly. Just to look at the technicalities that were raised in the review, what the government specifically wants to look at. Now, there are lawyers, eminent lawyers, who want to say a lot more than this. But I think codification is very worrying if, in fact, what it is an attempt to restrict by the executive, frankly. And I also find it hard to codify in the absence of what I indicated earlier, which is a wholesale proper piece of work that probably would have to be a royal commission on proper constitutional change. And therefore, what is the role of the citizen in relation to their ability to challenge those with power over them? And that's a much broader concept. And you'd have to sit it alongside lots of ways to effect change. Citizens' assemblies, for example, would be one way to do that. There's a live debate in England about the need for given devolution to Scotland and Wales, the need for a citizens' assembly of some sort and a proper chamber here in England. These are big, big constitutional questions. It seems bizarre to pick on judicial review in a narrow sense to go after. And I think there's some confusion. I thought we exited the European Union because we were determined to get sovereignty back to Parliament. And I don't understand, it's not consistent, it seems to me, to have a sovereign Parliament, i.e. you elect people like me on behalf of the people, you can kick us out if we get it wrong, and then to challenge the very people that, if you like, personify that. And therefore, whenever you're hearing government ministers talking about judicial review, the tendency is to be very conscious of the executive and hoarding executive power. This is actually a dangerous time to hoard executive power and to want no executive challenge at a time when, as a consequence of leaving the European Union, some power is returning to this country. But of course, it ought to be power that vests with the people, not just power that vests with the executive. And it's very, very worrying to hear Conservative ministers, backbenchers, who ask for that power to come back, then seeking basically to hoard that power in the hands of the current government. And it's foolish, of course, because whatever you think about our democracy, as night follows day, this government will not be in power forever. One day there will be a change of government, and therefore it's sort of petty and small to dwell on the currency of our times and not realize that those times change. So I don't really recognize the need for codification, and I'm very worried about changes to justiciability, because again, it's the executive ruling out what is in and what is out, and I'm just not convinced that that is necessary. Now, there may be some changes that would be very helpful. I've heard those who've talked about legal aid and widening legal aid, actually, so that these barriers do not exist in the way that they do. And given the need for a society, a healthy society where there are whistleblowers and where there's a duty of candor, it may be that we need to build that into the system. And those are procedural things that the opposition, of course, would support, and we in Labour would support. But I'm not sure that that is the intention behind what is coming from this folks review. And as I said, very, very worried about further restriction of judicial review. These feel like sweeping and dangerous changes that could be proposed. I'm very, very conscious, very sadly, that the Conservatives have an 80-seat majority. So if Michael Gove and Robert Buckland are determined to ram this view, it's going to be very, very, very hard indeed in Parliament to defeat them. It will need the entirety of civil society, the public, demonstrating that this is important to them. And really interesting to see that even those in the finance and banking sector are saying, what the hell are you up to? We actually really value judicial review. And again, in terms of success rates, you know, it's a 10% success rate. It's pretty low. Why are the government getting upset about such a low success rate? It can only be for political motive. And it's my sincere hope that looking at the wealth of submissions that have been made, even though they've not been made transparent, that the government think again. Thank you very much.
Thank you very much indeed. That's an absolutely excellent start to our conversation. Now, just to take stock of timing, if we may, for the benefit of all those who are watching and listening to us, we can continue until just before 6:30, so there's plenty of time for everybody to have their say. David, I know that you mentioned earlier, some people may have heard you say this, that you unfortunately have to leave us at about 6 o'clock.
And that's only because we're discussing the important issue of Brexit at the Parliamentary Labour Party meeting, and I think I ought to be there.
We wouldn't want to deprive your colleagues of your wisdom and contribution to that meeting. So I think what I'm going to do is to try and keep an eye on the clock and come back to you, shall we say, at just sort of 5 to 6, just for any further comments that you want to make. But in the meantime, James, I don't know if you can hear me. I know you had a few little technical...
Here, but I'm going to go off camera if I may.
Okay. So, James, if you could unmute yourself. So you should see a mute button at the bottom of your screen with any luck, and that's the one you need to press. I don't know whether Joe can unmute you.
I can't, sadly. I can ask him to unmute, but...
Okay, wait a minute. It looks as if you might have a helper there who might be able to assist. Hello, Mary. This is an example of socialist teamwork, I think. Success.
Now.
Well done.
Thank you. Okay.
So, James, we're all very, very grateful to you for all your input into this exercise, and particularly for making it possible for us to hear you with Mary's help, for which we're also very grateful. Would you like to introduce this summary of the submissions, and then we'll call on Sarah and Sam after that? Over to you.
Thank you very much. Mary's help, as always, is invaluable. And as you say, Stephen, we share many things in common, including both having been previous chairs of the Society of Labour Lawyers. You referred to the document being 75 pages, so it's certainly not lacking in width. But it's neither possible nor desirable to be either impartial or as brief as one might wish to be. The important issue of Brexit, to which David has just referred, an assault on the rule of law and the Supreme Court, in especially following the prorogation case to which he referred, and coronavirus currently, are quite a combination. And with this government, assault on judicial review today, and the threat, despite protestations to the contrary, of the second instalment of Brexit the day after tomorrow, namely an attack on the Human Rights Act and disengagement from the Strasbourg as well as the Luxembourg Court. The Human Rights Act, of course, was one of the great achievements of the last Labour government, and we must fight to preserve it. And it shows that the right balance can be struck between legislative sovereignty, democratic accountability, and judicial independence, and between executive power and obligations and citizens' rights. That balance must also be preserved on the domestic law front, with judicial review as the safeguard against dereliction of public duty and abuse of public power on the part of government, central and local. That is what underlies our submission to the Folks panel. The preservation of the rule of law and resistance to the government agenda that is all too readily apparent from the panel's terms of reference. We join David in opposing a restrictive form of codification, if not indeed codification at all, and argue that any form of codification would create more problems than it would solve. We, like David, are worried about justiciability, which is at the heart of the matter. Sam will focus on that. Justiciability, of course, is a vital issue of high principle, but procedure is also of the greatest practical importance. It's no exaggeration to say that cumulatively, the threatened procedural changes, all in the direction of greater protection for executive bodies and greater difficulties for potential claimants and their supporters, would be catastrophic. The thoroughly bad ideas include diminishing the duty of candor, limiting the duty of disclosure, restricting standing, excluding public interest and intervener groups, tightening time limits, and blocking appeals, and also a regressive approach towards costs and funding. Ultimately, of course, judicial review is not only about rights, it's also about remedies. And rights, of course, have little value without effective remedies. Sarah will focus on the vital topic of relief. Finally, we are not conservatives. We do not believe that all is for the best in the best of all possible worlds. We may appear to be on the defensive, but that is because the task of the moment is to resist a dreadful attack. But we are alive to the scope for positive improvements, and indeed the need for positive improvements, at any rate, by a Labour government after the next general election. And these improvements would include, for starters, clarification of the duty of candour in the right direction, and respect for the devolved nations within what may possibly remain the United Kingdom, despite the government's weakening of the bonds. Whether or not a written constitution is a good idea is a question for another day. We've had a great team contributing to our submission, and we commend it to the party in and outside Parliament.
Thank you very much, James. I think that it would probably be logical now, if I may please, to call on Sam, because I think you have been slightly more concerned with the substantive issues contained in the response, as James foreshadowed. So let me call on you now to summarise some of those aspects, and then we'll come to Sarah on remedies and other equally important topics. So over to you.
Stephen, thank you. So hugely grateful as always to be asked to be on this panel and to contribute to this. I, as you've said, predominantly looked at the issue of justiciability, and the way that was framed by the terms of the review was essentially a question of whether, or perhaps not even whether, perhaps just to what extent justiciability should be limited. And it was suggested in the terms of review that perhaps we might like to limit justiciability of questions based on the nature and subject matter of the power. And I'll come on in a few moments to why that is a truly terrible idea. But I think I want to start when talking about justiciability by stepping back a little bit, because ultimately, the question of justiciability is the question of the administrative court's role in our constitution. And as lawyers, we are certainly tempted to focus on the technicality of the question, and as a result, fail to consider the bigger picture. But I think in this case, we have to start by looking at the bigger picture, because as David correctly said, we are engaged in this review in a political debate. There is no question of law here. In fact, any question of law raised by this review was really quite comprehensively settled, I think, in the mid-1960s by Lord Denning and co. The fact that we're having this debate now again is a matter of politics. And so we have to begin by looking at the court's political role in the Constitution. Before I get into the detail of that, I think we also need to appreciate that we didn't get here overnight. This isn't something, a wheeze that this government has just thought up. This is part of a trend that has been going on for at least 10 years. And that trend is of an unfortunately conservative government's antipathy towards the courts and towards the enforcement of individual rights. And we saw that at the very beginning of the Cameron administration, with which legislated to limit judicial review and to limit access to legal aid. We saw it in the middle of the decade with Theresa May as both Prime Minister and Home Secretary, beginning attacking human rights, judicial review, and indeed making various false claims about that. And now we see it again with the Johnson administration attempting to prorogue Parliament, and Priti Patel and Johnson using their conference speeches to attack, well, they say lefty lawyers. I think what they're actually attacking was just lawyers who do the job of lawyers, which is to represent their clients in court. And this doesn't come from nowhere. There is an intellectual driver behind this and has been for a long time. And that is the think tank Policy Exchange, and especially the Judicial Power Project. And for those interested in an evaluation of that, I'd recommend Paul Craig's article on the subject. But to summarize, the JPP specializes in unevidenced assertions and really quite undergraduate analysis of legal issues. And while academically and legally it really hasn't got anything going for it, it's incredibly influential. And in fact, in the last 3 months, we've had the Internal Market Bill, the Covert Human Intelligence Sources Bill, and the Overseas Operations Bill, all of which flow from JPP research, and all of which, I should add, are entirely unevidenced. So when we're thinking about our response as progressive lawyers to this issue, we need to think not just about reacting, but as James said, providing a form of constitutional thought leadership. And this can't begin and end with this response to the review. We have to start looking at how we are going to begin our 10-year or 20-year project to set constitutional thought leadership back on the right track. And I think that has to begin, as our review of justiciability begins with looking at the court's role in the Constitution. And we often make what I think is the mistake of talking about the Constitution in a static sense and saying we have a democratic Constitution. And in fact, we don't. We have a Constitution that is on a centuries-long journey from an autocratic monarchical constitution towards a genuinely democratic constitution. And the Labour movement, certainly as the heirs of radicals like William Cobbett, is the inheritor of that mission. But we've still got a long way to go. And you can still see in our constitutional law hangovers of the monarchical constitution, not least, and I mention this because it's the area I have the most experience with, the royal prerogative, which comes from a suite of powers most exercised by monarchs, but defined most famously by Charles I, which is the monarch's ability to act without parliament. And I think as Lord Roskill put it in Fire Brigades Union, the history of our Constitution and the history of the court's role of the Constitution is the evolution away from this sort of monarchical conception and suite of powers towards a genuinely democratic suite of powers. And we're not there yet, but we're on the way. And one of the errors that I think that is inherent in the IRAL's approach is seeing the evolution of our Constitution, the judicial evolution, as a problem, as a bug in the system, rather than an essential feature. And the way we have got to our current understanding of justiciability is through evolution. And we began with began this story with the case of Padfield, a series of cases in the mid 20th century. And the one that I want to draw your attention to first is Padfield, because that was where the courts determined that actually it was a matter of law, what the extent and indeed existence of prerogative powers actually was. And so for the first time, the Constitution evolved in the democratic direction by bringing these formerly royal powers, formerly unaccountable powers, within the ambit of the law. And once that was established, it was then really just a matter of time and really obvious that if prerogative powers fall within the ambit of the law, then the way they are used must also fall within the ambit of the law. And this brings us to one of the administrative court's very important constitutional jobs, which is ensuring that the powers of the executive are exercised in a manner that is lawful, but perhaps perhaps when we say lawful, we mean two things. And one of those things is conforming to the law as set down by the democratically elected parliament. But the other of these things is conforming to the common law, and in a constitutional sense, the common law principles that make democracy work in practice. And obviously the most high profile example of that we've seen recently is the prorogation case, in which the Supreme Court, and in fact, it was the court of the inner house of the Court of Session that first made these decisions, which were then confirmed by the Supreme Court on albeit a slightly different analysis, which reached towards constitutional principle, which is well established, that Parliament is sovereign and the executive is accountable to Parliament. And therefore, when the executive does something, exercises its prerogative powers in a way which undermines this democratic essence of the Constitution, that must be unlawful. The story of justiciability continues with the case of GCHQ, which is when the courts decided that to bring the use of prerogative powers within the ambit of the court. But GCHQ exhibits two contrasting analyses of how we do this. On one hand, you have Lord Diplock's analysis, which is that the courts should look at the question before them and ask.
Forgive me interrupting you. If we can just pause you on Lord Diplock for a moment.
We'll always have to pause on Lord Diplock.
Come back to you in a few minutes' time, but I just want to give David the chance to come back in for a moment. It'd be nice just to catch a glimpse of you before you go off and talk about Brexit. Sadly, you've only heard part of the presentations.
Yes, but because it's being recorded, be under no doubt, I and my political advisors will be catching up on what's been said after I leave, because I do want to emphasise that this is actually hugely important to us. That the more technical aspects of the law are important to us, even though we cite this in a political guise. If we're being really generous and the government isn't playing politics, and this is going to be some small procedural change, then we want to know what those should be, of course, and therefore the submissions and what's been said is very helpful. And obviously, if our hunch is right and the government is seriously coming after judicial review, then we will want to mobilise in a very serious way. So the Society of Labour Lawyers is very, very important. The community, the broader legal community, is very, very important. And the challenge that we're seeing, I'm afraid we're going to have to resist very, very definitely. So, and that to some extent means also marshalling the sorts of people who rely on judicial review. It's a bit like the hacking case that broke open when Millie Dowler's parents were the face of hacking, and similarly, the face of judicial review is not our face, it's the people who relied on it, and it's the legal community who'll be able to reach into their back pocket of clients to actually get them to publicly front up why this would be an outrage. So I was very grateful to hear Sam's historic analysis, at least, because it was helpful. I'm so sorry I can't hear Sarah, and obviously James, very, very grateful indeed. Thank you so much, Stephen. Forgive me that I've got to go, but believe me, this is not the end of the issue or the matter.
Thank you, David. We wish you and your colleagues good luck in the days and months ahead. We're right behind you, and we will keep in touch.
Very grateful. Thank you.
Thanks very much. Okay, so Sam, let me come back to you, but it's now 2 minutes to 6, and if you could sort of accelerate your move through history a little bit so that you finish in the next 3 or 4 minutes, and then we can bring Sarah in for a few minutes and then open this up, if you wouldn't mind.
Lord Diplock in 2 minutes, no problem. Lord Diplock's approach was that we should look at the question, the court should look at the question before it. Lord Roskill took a contrary approach, and that was that we should look at the nature and subject matter of the power. And the short version of this is that in the 30 years since, Lord Diplock's approach has been consistently preferred. And the reason for that is that the nature and subject matter of the power asks the courts to engage in a conceptual discussion for which it is not equipped. Ironically, it gets the court closer to engaging in politics than almost anything else. However, we've seen it in a number of cases and arguments put forward in cases on behalf of the government, a sort of resurrection or attempt to resurrect the Roskill approach by introducing this idea of high politics. And I use my quotation marks here because high politics is an entirely empty concept. It can mean pretty much anything and often is used to mean anything. Most problematically, it is used to mean that the decision the court makes will have political impacts. And that is, of course, not the court's problem. The court must decide whether it looks at a matter of law. It shouldn't care what the impacts of that are. And the reason I say this is because it provides the answer to the panel's question, which is, should we look at the nature and subject matter? And the answer is emphatically no. It is not the court's job to engage in a sort of abstract reasoning of the power before it. The court's job is to ask, has the government acted unlawfully? and only and it should look it should look no further than that. So I would urge us to move in the opposite direction of that envisaged by the terms of reference, and that's throw out all of this rubbish about high politics or the courts interfering in politics or the nature and subject matter of the power, and ask, and indeed the non-justiciability of archaic prerogative powers, and simply ask, what is the law? Has the government acted within this? That's all the court should be concerning themselves with, and that's Diplock in 1 minute.
Thank you very much, Sam. Lord Diplock would be proud of you. I'm now going to invite Sarah to unmute herself and to speak to us, and we're looking forward to hearing your contribution.
Thanks very much, Stephen. It's wonderful to follow Sam's clarion call for constitutional thought leadership to the participants on this call. I really feel like we're duty bound to engage in a project which is going to last at least 10 years. So thank you for that rousing, those rousing words, Sam, and also to James, Stephen, and of course, David. So I want to start with a quiz question.
Sorry to interrupt you so soon, but and you mentioned constitutional thought leadership on the part of the audience. That might be a bit ambitious, but if one or two of them could add some questions to the Q&A box at the very least, that would be welcome. I've got 3 so far, so we could use a couple more. Thank you very much.
Well, I've got a question for them, Stephen. They can put the answer in the chat. So we'll start with a little bit of a Society of Labour Lawyers legal quiz. Who said the following? And I quote, "We appreciate speed as we don't want to give those Marxists loads of dough for nothing." We appreciate speed as we don't want to give those Marxists loads of dough for nothing. I'll give you 20 seconds to pop it in the chat. First correct guess gets a beer at the next time we're able to meet in person. Oh, we've got some excellent answers. Richard Branson, not quite. Boris Johnson, also not quite. Robert Jenkins, not yet. Prize goes to Adrian. The answer is Richard Desmond. And the context, I owe you a beer, Adrian. The context of that quote was a text message sent by the property developer and erstwhile Tory donor Richard Desmond to the housing minister, Robert Jenrick. And as many of you will be familiar, the context for that quote was a planning application for the West Ferry print works on the Isle of Dogs in Tower Hamlets. Richard Desmond was the developer, and he was very keen that in terms of the timing of his much hoped for grant of planning permission, that the timing of any grant of planning permission would come at such a time so that he could avoid paying what amounted to about £40 million in community infrastructure levy. There was pre-action correspondence when that planning permission was granted, sure enough, just in time to avoid the levy, which claimed apparent bias on the part of the minister, next to whom Richard Desmond had sat at a recent Tory party dinner. But in response, the government said that the apparent bias claim wasn't substantiated. Now, once judicial review proceedings were issued, faced with the prospect of complying with the duty of candour, the government quite properly accepted that the planning permission that had been granted was indeed unlawful. And that therein is the power of the duty of candour. That case, the West Ferry Printworks case, shows why judicial review matters in terms of holding the powerful to account. It shows why it matters in terms of fair treatment in accordance with the law, in terms of its role in upholding the rule of law, and in promoting good governance and standards in public office. It's also an example of where judicial review proceedings were issued, but didn't go the full course, didn't end up in a High Court hearing. There is no judgment in the West Ferry case, but where judicial review played its part in having precisely the sort of corrective effect that we would hope administrative law would have. And indeed, there is research to show that roughly about 60% of possible judicial review claims, very often against local authorities and other public bodies, as we've heard, settled before proceedings are even issued. They operate within the shadow, if you like, of judicial review procedure, but they are very much part and parcel of what ensures judicial review's effectiveness. So what this example shows is why, as James said in his introduction, and also as we say in the introduction to our submission to the IRAL, that procedure is every bit as important as substance. And it's also in the context, I would speculate, that it's in the context of procedure that we are most likely to see practical changes coming out of this review. That's not to say that codification and justiciability aren't terribly important, but it's in these areas where, as James said earlier, and I think you're absolutely right to make this point, both in specific procedural areas in and of themselves, but also as a cumulative package, the chilling effect that this could have in deterring claims of judicial review and in undermining the effectiveness of the role that the Westbury Printworks proceedings demonstrate, that we could see very damaging changes indeed. So I commend the document to you. There's lots in it. Go away and read it. What I want to do in the few minutes that I've got left is to touch on 3 of the areas very briefly that we covered under the procedural aspects of the call for evidence. The procedural aspects covered everything from the duty of candour, remedies, standing, timings, the role played by interveners, rights of appeal, and much, much more. I just want to say something brief about candour, about standing, and about remedies before chipping in with some concluding remarks about the politics of all of this and Adrian's question in the chat, which I suppose poses the question, how do we as lawyers and as members of the legal community and as citizens make the case for judicial review outside of these very important but what are otherwise technical issues? A sentence before I touch on those areas, which is that in the call for evidence, where the call for evidence touches on procedural reform and call for evidence, it did so in the context of, and I quote, whether reform was needed to streamline the process. Now, the notion of greater efficiency, of lower costs, of swift justice is a good thing. And indeed, if you read our submission, you'll see that it focuses not just on threats that we anticipate, threats to the duty of candour, to narrowing rules of standing and things like that. We also propose reform where we think positive change could liberalise judicial review, make it more accessible and less costly to the average citizen. So there are things that we could change for the better. We shouldn't find ourselves in defence of aspects of the system that are broken, and our submission very much does that. However, there is, as others have already noted, clearly when viewed in the context of all the noise about antagonising activist lawyers and the disruption that this government is causing to our constitution more generally, a lot to fear in what is euphemistically called an effort to streamline the process. So picking up on a few of the points that we raise in our submission. Well, the Westbury example shows you just how important the duty of candour, which requires all parties, but in particular defendants, to give a full and accurate explanation of the decision-making process. It's vital. It's a vital duty in terms of inviting parties to put their cards on the table and reminding public bodies that they shouldn't be adopting a winner-takes-all attitude. Part of the fundamental purpose of judicial review is ultimately to improve standards of administration. And so the duty of candour and compliance with it is a vital aspect of that. We argue in our submission that any abrogation of the duty of candour would damage the rule of law and would actually end up escalating costs if we ended up with a much more generalised and less focused duty of disclosure. We do call for clarification on the timing of when the duty of candour kicks in, and we also call for clarification on the extent of that duty, but fundamentally we say it should stay in place. Second, I want to say something about standing. Lots of you will be familiar with the sufficient interest test. You've got to show sufficient interest before you can bring a judicial review. The call for evidence focused very much on the role played by public interest challenges. These are when challenges are brought by NGOs, public interest groups, who have something to say and a challenge to bring. We argue that it would undermine the rule of law fundamentally if unlawful decisions were immune from challenge simply because no particular individual had come forward who had been directly affected by that decision. It remains the case that not only does that enforce the rule of law, but public interest challenges can actually often streamline the process, if you like, reduce costs because you've got an NGO with expertise that can present a focused challenge in a professional way, consolidating a number of related points rather than bringing lots of different claims which may miss their target. Thirdly and finally, remedies. We know that in judicial review, remedies are not a matter of right, but they're discretionary. Our courts, who, as Sam and James have alluded to, have built up a tradition of administrative law, are adept and skillful and pragmatic when it comes to balancing, on the one hand, the need to address public law wrongs, and on the other hand, recognizing the administrative burden and practical realities that that the grant of remedy can sometimes touch on. The introduction of section 31(2)(a) for the administrative lawyers on the call of the Senior Courts Act 1981 lowers the test for refusing relief. This was brought in recently, and the effect of it is, to put it simply, that the High Court must refuse any form of relief if it considers it's highly likely that the outcome for a claimant who's established that a public body has acted unlawfully would not have been substantially different. We could see from all our researchers that there was no evidence that such a change was needed. The courts, as I've said, are experienced at balancing the considerations, the practical considerations that go in to ensuring effective relief. And this basically sets the bar too high and frankly gives the impression to some public bodies at least that they can get away with it even if they're found to have breached their public law duties. So we say that provision should be rolled back and the Simplex standard restored in the area of remedies. There's lots and lots and lots in the submission. I obviously haven't got time to go through each and every bit, but I really would thank the team of contributors that put together our response on procedural reform. Before I conclude, I just want to say something very quickly about the politics of the review. In the terms of the procedural context, there is no evidence, and this is very well covered in the Public Law Project's response to the IRAL. There is no evidence of the courts being flooded with unmeritorious claims. The procedural structures which govern judicial review are very effective at filtering out such claims, not least through the permission stage. The problem, if anything, is the opposite, and the barriers to open, accessible judicial review, which frankly the Labour Party should be committing to tackling if we get into power, are there to be brought down and making judicial review more acceptable. Chief amongst those are what we've heard David mention tonight, the narrow availability of civil legal aid, the cost risk faced by a potential claimant in the absence of effective cost protection for most litigants. And of course, more generally, this culture of denigrating those who would bring a judicial review, which, let's face it, even when in government, the Labour Party and some of its representatives didn't shy away from. So we too have to ensure that we are defenders of judicial review, whether or not we're the ones whose decisions are being challenged. But to pick up on Adrian's question, this is the final point, we do need to explain why it is that judicial review matters, why it matters not just to folk in the legal community, not just to folks who perhaps represent more marginalised in society, although that's very important, whose rights are most likely to be interfered with by the state, but why judicial review is there for everybody. There are some really good efforts at doing this. The Each Other project, which grew out of Rights Info, is an example of public legal education explaining why these rights matter. Cases like West Ferry, like the judicial review of the parole board in respect of John Warboys, judicial review of the West Coast mainline tender, things which ordinary folk would look at and say, well, that's just unfair. The Windrush example that David gave, explanations as to why judicial review matters to the man in the street, matters to those in finance, as much as it matters to those of us who are, if you like, steeped in constitutional law and know why it matters historically and know our Lord Diplock from our Lord Denning. I think it's really, really important. And I think that can be a challenge that the society takes up going forward. As others have said, the submission is a piece of work that I think the whole team and the wider team, we're really proud of, but it's got to be the start of, to take up Sam's phrase, the start of constitutional thought leadership, not the end.
Thank you very much, Sarah. Now, our wonderful administrator, Joe, has assured me that if I identify someone who wants to ask a question, he might be able to bring them in on screen so that we can see and hear them. He'll correct me if I'm wrong about that. So we've got a couple of people who have put questions down, both of them in a way dealing with the point that Sarah was just mentioning, as it were, how we get across to the public at large the importance of judicial review. And I'm going to ask Joe if he can bring in first our colleague Thomas Webb, who's got a couple of questions in the Q&A. Can you do that, Joe?
I can, yeah. Give me a second. Alternatively, I'm not sure if people who've written them want to speak, so you may just need to read them out and then...
Right, okay. Well, Thomas, to save you from having to come on screen, in essence, your question really relates to the way in which judicial review is taught at the stage of the training of lawyers, and what you're suggesting is how can we improve the training of lawyers so as to enable people from all walks of life, as you say, to be able to take the judicial review baton. And you're suggesting that we should work not only with the Bar Council, but with the solicitors' representative bodies, so as to try and bring that about. So I'll invite the panel to comment on that in a moment or two. But we've also got a question from our treasurer, Adrian Williamson, who's already been referred to. Joe, I don't know if you can bring in Adrian, can you? That might be a possibility. Just see if you can do that, and we'll get him to add anything he wants to his question, which I've already mentioned. We may be able to hear you, Adrian, even if we can't see you.
Can you hear me now?
Yes, we can.
Right. So the question that I raised, and which Sarah was alluding to, was for all the panel as to how they think the case for the rule of law generally and judicial review in particular can be made to voters, for example, in the blue wall, red wall areas, who support Brexit and who believe that the judges are liberal hand-wringers and enemies of the people.
Okay, so I'm going to invite each of you to respond briefly to this sort of package of questions. Adrian's point being obviously extremely topical, how we persuade people outside the political mainstream to understand the importance of judicial review, but also Thomas's point about how we can improve. He says legal education, but perhaps we should include all kinds of education in order in the longer term to help with this, to help achieve this objective. James, would you like to start us off on this question?
Well, it's a little while since I was myself a law student. So I think I'll pass on the question of how current legal education might be improved. But I was taught by Professor De Smith and Professor John Griffith. So I had an excellent grounding at LSE. Obviously, there have been many developments since. And indeed, I appeared in the Fair's Fair case for the GLC. And the GLC had had no legal advice at all before it introduced its fair's fair policy. After the House of Lords did them down in the fair's fair case, no one would take out a handkerchief in County Hall without having at least 2 QC's opinion. Things went rather from one extreme to another. But the fair's fair case, of course, is an instance, of which there have been many more recently. The judges don't always find for claimants, and indeed more often than not, very much more often than not, particularly if one takes refusals of permission as well as the ultimate outcome of cases, find for defendants. So they do adopt a balanced approach. And it's quite right that they could, because I think we need to be aware that it's not always a case of the goody claimant and the wicked defendant in judicial review. Sometimes the defendant will be, say, a Labour local authority or a Labour government, which is doing something in the collective interest, and more especially for those who are the more disadvantaged in society, and find, as indeed with fair's fair, that those who are rather more privileged are mounting a challenge, or those that are already very well housed challenge social housing projects and that sort of thing. So the defendant may be in the right and the claim may be unmeritorious, and judges understand that. And although, of course, they don't always get it right, I think broadly they do. So, I mean, I think in terms of trying to get across things to the general public, one does need to try and emphasize the point that the cases that may hit the news media, and in particular certain parts of the news media, are not necessarily at all typical, and are not necessarily, of course, well represented, and that whatever one's views on a particular subject like Brexit, and whether one's in the north or in the south of the country, judges are an essential bulwark against oppression, and are very much in the interests of everyone. But it's a difficult sell, because although, of course, 95% of people are in favour of the rule of law, 110% of people are against the rule of lawyers.
Thank you very much. So, Sarah, can I turn to you for your comments on this topic generally raised by Adrian and by Thomas?
Yeah, absolutely. I mean, I think in terms of the reputation of judges, I think it's interesting. On the one hand, probably quite understandably, they're seen as part of an elite, London-centric, all the rest of it. But it's also interesting that in a context where I think erosion of public trust in political figures, following the hacking scandal, in journalists, and other sort of groups, it's interesting that if you look at sort of public attitude surveys, judges, as distinct from lawyers, actually remain in pretty high esteem. And you look at what the reaction of politicians is when we have a difficult or highly sensitive political subject, and it's let's order a judicial inquiry. Look at Grenfell, look at the sexual abuse inquiry, look at the phone hacking inquiry. Let's order an inquiry because actually we believe that these are the individuals who have the skills and the impartiality to get to the truth of things. And those, interestingly, just to take those 3 examples, are all issues where I think men and women in red wall, blue wall seats, in common with those in metropolitan areas, would say it's really important that the victims or whatever in those situations get justice and we get to the truth of what happened. So I think if you then translate that to the context of judicial review, I don't think we should assume that judges are sort of universally sort of held in ill esteem, whatever the front cover of the Daily Mail might say. We do obviously need to defend them, and our Lord Chancellor should have defended them more robustly in that context. But I think if we can tell a story about examples of where judicial review, whether for the claimant or for the defendant, has operated in a way that is pragmatic, that got to the truth of something, that was really targeted at fairness. I gave the example of the War Boys case and the judicial review of the parole board. I think a lot of people, including in your blue wall seats, would say, yeah, that plays a really, really important role in our constitution. And therefore, leading to the other question, it's vital that it plays an important part in our legal education. I just wanted to pick up on one question before handing back to you, Stephen, and to Sam. Another question I spotted from Chloe in the chat, and Chloe, I know, has been sort of very, very supportive and made a big contribution to our submission. But the question that she asks is, how do we negotiate this issue about Labour defending the status quo when it comes to judicial review, even where we think aspects of that are broken, and actually proposing positive changes? I think what I would say is it's very difficult to do in this highly politicised context. I think David's right. First and foremost, we've got to be ready to do what we can to resist what looks like the efforts on the part of this government to abrogate and restrain judicial review. That doesn't mean we shouldn't have good ideas for if and when we get into power. And I think it's important to feed that in. I mean, Keir Starmer's talked about things like a constitutional convention, and that may be part of a bigger conversation that we need to have, bringing in wider themes. But we should have positive ideas. We don't just want to be defenders of the status quo. So I think we should take up Chloe's invitation, but I think it may be politically dangerous to do too much of that in the context of this review, where we know an attack is coming.
Thank you very much, Sarah, and thank you for dealing with Chloe's question, for which we are very grateful. Sam, I'm going to give you the last word, but you've only got 2 minutes because I'm under strict instructions to finish by 6:30. Just take note, please, if you will, of a final question by our colleague Nigel Duncan, who makes the point that rather sadly the solicitors' new qualification arrangements do not, it seems, involve a course in judicial review, and you might like to comment on that, along with dealing very, very briefly with the more general question.
Well, Lord Diplock said, no, I'm joking. I think I concur with everything that James and Sarah have said on this point, so I don't want to repeat it. The point I do want to make is we need to see educating the public as a long-term project. This is not something that we'll do overnight, because the thing is, it's not something you can get across with a quick soundbite. It's educating the public about the Constitution is about getting people to buy in to a long-term positive vision of who we are as a nation. And you can't do that overnight. You have to spend 10, 20 years doing it. And the reason I know that is because that is exactly what Policy Exchange and JPP have done. They kicked this off in 2003, and their stuff is now just coming into fruition. So we have to be prepared, and we have to create the infrastructure to play the long game. And we also have to treat, I think there tends to be a tendency to sort of treat the people in the red wall or the blue wall as this sort of external species that we have to go and talk to. I'm actually from the red wall, now the blue wall. We're not an external species. Everyone's capable of having an intelligent debate and buying into to ideas of the Constitution and understanding it. And I think we should just go and tell people about it. And if it doesn't work the first time, we should do it 50,000 more times, and then maybe it will. So possibly unsurprisingly, my final 2 words are going to be thought leadership, because I think that is what we need.
Thank you very much, Sam. Let me assure everyone that this is certainly not going to be the last word on constitutional and human rights issues so far as the Society of Labour Lawyers is concerned. We're setting up a human rights group deliberately, specifically to focus on that particular topic, led by Omar Salem. We are looking at other aspects of constitutional reform, and you'll be hearing quite a bit more about that in due course. As several people have already said, this is not something that we can deal with in a couple of weeks or even necessarily in a couple of years. It's probably an issue to be considered throughout the present Parliament in readiness for the time when Labour moves into government, as we all hope it will. Can I particularly thank every colleague who has joined this session. I hope that you've enjoyed it. And as I said, you can listen to it again if you want to. And I hope you'll continue to keep tuning in to future webinars. And thank you finally to Joe, our invaluable administrator, for all his help. And I wish you all a very good evening. Thank you.
Thank you, Stephen.
Thank you, Stephen.